and I am a litigation attorney with Brent, Adams & Associates. Mr. Adams has practiced for over 50 years, and our law firm together has well over 100 years of experience between attorney Chris Wenker, Emily Hickman, Takina Horn, Amy Wabike, myself, Diana Devine, and attorney Sheila Chavis, our workers' compensation specialist and partner, as well as attorney Vance Jennings, our Social Security disability specialist and partner. We are a law firm that is here to help you with various legal issues you may encounter, from workers' compensation to compensate for injuries to disability claims and various other situations. We hope you will call us when you need assistance. We can be reached at 910-888-8888, and we handle cases all over the state of North Carolina. We say don't hesitate, call the 8. We have offices in Dunn, Fayetteville, here in Raleigh, Southern Pines, as well as an office in Clinton, North Carolina. Making the law, if you please feel free to give us a call at 910-888-8888, or you can visit us at www.brentadams.com or on Facebook. Our expert team of intake specialists is happy to hear from you. So once again, the number is 910-888-8888. We make things right. So today we're going to talk with one of our case managers. I'll let her introduce herself, and she's going to ask some questions that clients have been asking her to me so I can explain them in more detail. When you call into our office, 910-888-8888, and you speak to one of our intake staff, you can usually get on the phone with one of our attorneys. You know, we have myself, Emily Hickman, Takina Horn, Amy Wabike, Chris Wenker, as well as the partners and the big boss would be available to you. You can usually talk to any of us. If they're not able to get us, you can schedule a call and we'll talk to you about your case right away. I tell people all the time, if you've been injured in any way at all, please give us a call and let us know if there's some responsible, liable party out there. All right, I'm going to turn it over to introduce you to Bonnie. Bonnie, tell us a little your name and a little bit about yourself and how long you've been with Mr. Brent Adams & Associates.
Hello, I am Bonnie Shaw. I've been with the firm for a little over 2 years. I am, as Diana mentioned, a personal injury case manager, which means I help the attorneys with the day-to-day paperwork, opening claims, talking to insurance and medical providers, and getting clients the treatment they need.
All right. I also have one of my interns here. I'd like to let him introduce himself in case he wants to put any information in while we're talking today.
Hey, good morning. My name is Jacob. I've been here for about 2 months. I'm currently a law student up in Pennsylvania.
Thank you. All right, Bonnie, you want to shoot some questions at me?
All right. So when we are working on a case for a client in the pre-litigation phase,
okay,
what is the policy limit? What does that mean?
So that's a great question and a very detailed answer I can give you. So policy limits in North Carolina prior to July 1st, 2025, if your policy was in effect before that and not renewed after that until the year. So every single policy now after July 1st, 2026 should be the new law, which the minimum policy limits would be $50,000 with a mandatory underinsured coverage of $50,000. So every case in North Carolina has the potential to receive up to $100,000 in coverage for your injuries if the injuries, personal injuries warrant that. Prior to that, it had been $30,000 since the 1980s was the minimum policy limit, and there was a set off for UIM. So like I have $100,000 in UIM coverage, but if I was injured prior to this and the defendant who hit me only had a $30,000 policy, I would only be able to get 70 out of mine. So the new law changed that, which I feel like was just a correction, because if I paid for $100,000 but I could never get $100,000, I didn't understand the purpose of that. So that has been now corrected in July 1st as well, and no longer an issue. So, but before that, if it was $30,000 and you didn't have any UIM, because UIM was not mandatory, and it Oh, this is Attorney Diana Devine.
You're back on the air.
Thank you. All right, we were talking about the policy limits, the maximum policy limit. So here's the thing that people don't, that I think is the most important to express to clients. I had a client the other day who was upset about this, and apparently so did Bonnie. So the $30,000 policy limits before, that is all there is. And in North Carolina, if you didn't have UIM coverage, and before it wasn't mandatory, remember, or for any reason that you just didn't have the underinsured coverage, then $30,000 is all you could get, even if your injuries were far worse. So if you did take it all the way to trial and you got a judgment against them for more than $30,000, please understand that the insurance company is only responsible for that $30,000. If we got a $50,000 verdict at trial, then $20,000 would be the responsibility of the actual defendant who hit you. But here's the thing. In North Carolina, I usually joke and call it debtor's paradise because there's nothing, we can't garnish wages for this. They can claim bankruptcy and the debt just disappears. You can't attach, if they only have one home and the defendant, doesn't really have any assets, or if they don't have good credit, they're not going to care anyway. You can do certain things to try and get the money, but it's very costly and expensive, and it's not something that is easily done to try and do, what is it? It's called a motion to have exemptions designated. Like, it's very convoluted law to try and seize things. And you can, pay a sheriff. Of course, this is all money that has to come out from somewhere to pay the sheriff to go and seize things. But if they have a car that has a loan on it, can't get that either. If they have anything, they can just say everything in the house belongs to their wife or their mom, or it's very hard to collect debts in North Carolina. You can only garnish wages for child support, alimony, IRS, really. It's not like Virginia or Georgia where they can do a lot of other things around us, but I believe South Carolina has those laws. So it's just very rare. We do an asset check on defendants to see. Now, if they do own multiple homes, that's great. Now we're talking where we can actually do something that's not going to be a huge amount of cost and expense and time that hopefully will get you, that has the potential to get you more funds. If they own multiple homes, they cannot claim that in a bankruptcy, right? So it will, and we can attach that $20,000 judgment onto their second home. So anytime that house sells in the next 10 to 20 years, you got to renew a judgment. There's still some other things that need to be done. Then it could attach. So we look. That's the first thing we look for when we think we have excess verdict, we could get an excess verdict. Is, does this person have any assets? Will they care? Will they try to come up with the $20,000? Is it a doctor that owns an 8,000 square foot house? That'll probably give us the $50,000 that's owed out of his own money. That's happened. But other than that, or we've had where it was landlords who owned multiple houses and paid the money out of their own pocket, or we could do something called a judgment where they say they have to pay the money at a certain amount of time, or it will attach to the house and it'll automatically attach. We've done that before as well. There's lots of different avenues, but that is not commonplace. Most people, if they have a $30,000 policy and that's all they have, and they don't have any other coverage, now it would be, of course, $50,000 minimum. But after July 1st, or as of July 1st, 2026, all policies should be $50,000, or whenever they were renewed. But if they have a minimum policy, and they usually don't have much more. But of course, we always check, right? Our goal is to get our clients as much money as possible for their injuries. We're trying to get them as best that we can. The best verdict, we make things right, is our slogan here. And our motto, of course, is don't hesitate, call the 8.
You had mentioned, Diana, how that set-off law changed, so you now have full access to your UIM coverage.
Yeah.
Can you talk a little bit about how that happened, like the NCAJ?
Oh, yeah. So North Carolina Advocates for Justice is the largest plaintiff trial attorneys or plaintiffs attorneys in North Carolina, an association of ours. And they work together to lobby the legislature and work on both partisan sides of the table to get us updated from the 1980s $30,000. Now, this is a wonderful victory for us. There are states now, because we have what's called contributory negligence in North Carolina, which means if you're at all at fault, then you get nothing. Everybody pays their own cost. Every other state except for 4 states in the country have some type of comparative negligence. So it doesn't matter really whose fault it is. It's really based on a percentage of fault. So the policy limits are very low because you get to claim on your own policy, basically. It's very different, very different. So in North Carolina, though, if it's your fault, like that defendant, they don't get anything for their compensation for their personal injuries. They don't get to go after their UIM. The only thing they can get is med pay. Med pay is very important. I think everybody should have at least $10,000 in med pay. It's very cheap. You can keep it on your own policy, and that will cover your medical expenses if you're in an accident and it's no fault. So even if the crash is your fault, you can still get your med pay. Even if it's not your fault, so we get med pay for our clients too. It works on both sides. It's coverage for everyone in your car, including yourself, no matter whether it's your fault or not. So you can claim that. So if this person has $30,000 in coverage, then that's the case that just came up. And the client was very upset because that's all there was. She didn't have any UIM coverage. She didn't have any med pay. The defendant doesn't have any assets. And so $30,000 is all that's going to be able to be gotten for her. That's the best verdict for her, the best amount we can get. And there's nothing more that you can do. You got all of the money is what I say. This is all of the money. And it's because there is no other money. The defendant doesn't have anything. And the client didn't have any med pay or UIM. And there's no other entity. It was just the defendant that had a minimum policy that caused the crash. There's no one else we could go after for any of the injuries. There's no one else at fault, just that person. And unfortunately, that's all the money. And that's what I usually try to explain to them. And it doesn't, some people are very upset with that because it's not enough. They feel it's not enough. But unfortunately, that's all we have here. It's not like in other states with comparative negligence where you can get on multiple policies. Now, if you have UIM or because there was a tender, so we're talking about UIM. So UIM is underinsured coverage. That means that the other party, the defendant, the at-fault party, has paid all of their money. That $30,000 or $50,000 has been tendered or given over to and given up, right? So that means all of the liable person's money has been paid. Now that is the trigger that kicks in underinsured coverage, underinsured motorist coverage, UIM. And that means that your damages were more than what the policy limits that were tendered, right? So if you had a knee surgery that was $80,000 and this person only had $30,000, obviously, and you have UIM, obviously UIM should pay, right? Because it's more damages than was tendered from the liability. And hopefully you have UIM coverage. Now remember, after July 1st of 2025, all new policies that have renewed, which should all be done as of July 1st, 2026, have $50,000 minimum and $50,000 UIM. So we're much safer, much more covered now in North Carolina because of this new law that's changed. So if there is an $80,000 surgery, at least there's enough money to cover everything and a little bit left over, but not very much. And there's also lien statutes out there. We could talk more about that. But when it comes to UIM, it's also very cheap. But again, now it's mandatory, so everybody should have it. And I do recommend getting at least $10,000 or more in med pay. So that doesn't matter if it's your fault or not. You can at least get that because in North Carolina, we don't have that. What else about UIM?
I was actually thinking of UM. Sorry.
UM. So UM is so UIM and UM are very different. UM is uninsured motorist coverage, and UIM is underinsured motorist coverage. So let's say that you get into a crash with someone who is uninsured. They really shouldn't have been driving at all. They've never had a license. Any situation that would have come up that the person who hit you, the defendant, the liable person, did not have insurance. So in North Carolina, the law has always been your policy covers you. But now there's no punitive damages. So if they were a drunk driver, or they hit and run, or they were speed racing, and there was like punitive damages could be attached, it's not allowed to be attached to your own policy. So UM would be whatever yours is. So if you have just a minimum $50,000 policy, that's all you can get is $50,000. UIM does not attach on top of that. And I've actually asked to see if there is a way that we could do that. If you get UM and UIM, I'm not 100% sure under the new law because there's no set off if that works or not. Now, I haven't had a UM that has been damages over enough to reach that's tendered to a UIM yet because the law is so new. But believe me, I'll ask. I will definitely request it. And what probably is going to happen is that there's going to be something in the policy that might go against it. So in those cases, we need copies of the policy. All of these, we should be getting copies of the policy just because you just don't know with the change in the law what policy it's going to be. You have to make sure that the policy that you get is in effect of the date of the crash. It has to be the policy that was in effect on the date of the crash. But it's a statutory regulation in North Carolina. All North Carolina drivers are covered under this statute that if an uninsured driver hits them, their policy kicks in to cover them, right? That's the UM, that's uninsured coverage. UIM is something extra that you buy to protect yourself from an underinsured coverage, right? So if you have a terrible crash and you're very injured and they have the $50,000 minimum, but you're far succeeding, beyond that, you have extra coverage to cover yourself that you can go after. That's the difference.
And so if you're involved in a hit and run, is that also UM?
It can be if we can't find them. So, like, I've had a case where it was a hit and run with an 18-wheeler, but we tracked them down and we found them and got their policy. But if we couldn't, now I have another one, an 18-wheeler hit and run. They're based out of Mexico, and I don't think we're going to be able to find them. And so then it becomes a UM claim. If we cannot find the defendant, the one that we did find, that state trooper went above and beyond. The client was very lucky. The truck that was riding right behind her had a dash cam and videotaped the entire thing. And it was so egregious that the state trooper went after the company, found the driver, and arrested him.
Wow.
Yeah. So therefore, even though it was a hit and run, it wasn't a UM claim because we found the driver, right? If it's a company vehicle, we can usually track down, we can sue the company and find out who the driver was. And that's what I'm doing in the other 18-wheeler hit and run case. But most of the time, if it's just a hit and run and we can't find the driver, then that's when UM comes in. I've had 2 or 3 where it was a hit and run, and they were drunk apparently, and they didn't make it far, and they wrecked the car, both of them. They wrecked the car like a few miles away, and so we find out who the driver is because even though they ran away, they were obviously shouldn't have been driving, and they never made it back to where they were, and they crashed. So that's happened quite a few times. This is like, I've been doing this a long time, so I got lots of crazy stories.
We do encounter a lot of unusual behavior.
Yeah. Personal injury is very fun. Every case is different. Every case is different.
We have a client who saw the person who hit them throwing bottles out of the car and he drove away, trying to get away, but he did not get very
Oh, he didn't crash? Yeah, no. It happens. So much more than you think.
You mentioned that we get the policy. Is that so attorneys can review the insurance policy?
Yeah, so every single policy is different. There's general guidelines, like usually there's a set off for MedPay and UIM, so because it's coming out of the same spot, or UM. So your insurance, you pay for UIM coverage and you pay for MedPay. And so the majority of policies set it off. So even though you have $100,000 of coverage, if you have $10,000 in MedPay, they just give you the $10,000 because they have to, but they'll try to set it off and only say you only have $90,000 left. But not every policy is like that, so you need to find out, do I have $100 or do I have $110,000 in coverage, right? Or 50 or 60, whatever it is, depending on the amount of UIM coverage you have and MedPay. Does it have a set-off clause or not? And then we're arguing that with the new law, because the law is new, so there's lots of of cases coming out to see what we can and cannot get, and whether or not that set-off is going to apply to MedPay or not. We'll see as the cases progress and what the policies say. And even if they do say that, are we going to be able to get it changed? Like there's, especially when it comes to like fleet vehicles. I just recently had a very bad crash, and it was a friend of mine. And so she immediately came to me, and I took it, and it was a blasting company. So it was an inherently dangerous, company. So they had a defense attorney that contacted me. So even though we were just in pre-lit, we were just treating, I hadn't filed suit yet, I was dealing with a defense attorney. So we sent our standard request to get the policy limits disclosure, and he refused. And I was like, you can't refuse. By statute, you have to. And but he alleges that the vehicle is a fleet vehicle, which is an exclusion to that policy. I was like, well, I have no way of knowing it's a fleet vehicle, sir. So you need to verify that it's a fleet vehicle. And so now I'm fighting with him. He apparently is a trial attorney like me, so I've only started doing pre-lit this past year. And so I think I might just have to file suit and play on a level playing field with him so he knows what's happening. So that way I get whatever I ask for because he has to. So I'm debating with that one. I'm going to talk to my intern and start drafting that one up because I feel like that's just going to happen. That's one of the great things about coming to Brent Adams and Associates. So all of us are, we all now deal, we rearrange things and we deal with cases from the beginning to the end. So even if you have to file suit, then I'm still going to be your attorney now. Your case manager will change from a pre-lit case manager or paralegal to a litigation case manager paralegal. But your attorney will stay the same. You'll be with me from the beginning to the end, and as with everyone else that you deal with. We are all trial attorneys. When you're looking for an attorney, you want to make sure that your attorney has been to trial in the past year or two, right? So there are lots of attorneys out there that have never seen the inside of a courtroom. You do not want that as your attorney. You want someone who is fearless, who is going to walk in and file suit, and is going to aggressively go after the insurance company and the defense counsel. And that's just the way it is. I'm sure that the insurance company keeps a record of us attorneys just as much as they keep a record of everything else. So having someone like me who's been to trial and just beat up a defense attorney is much better for your case than someone who's never filed suit in their life. That leads me back to our little speech. So we are listening to Making the Law Work for the People in the WIDU 1600, sponsored by Brent Adams and Associates. Don't wait. Call the 8-910-888-8888. Mr. Adams has practiced law for over 50 years, and we all together have a combined over a century of experience between us attorneys. Mr. Adams has written many books. Amongst them is The 10 Costly Mistakes That Wreck Your North Carolina Case, How to Get Top Dollar for Your Workers' Compensation Claim, and Mr. Adams' newest book is The Truth About Medical Malpractice Claims. These books are available for purchase on Amazon.com. But as a loyal listener to WIDU, you can call our office to get a free copy sent to you in the mail. So reach out to us, 910-888-8888, and we'll follow up with a free copy of Mr. Adams' book. Don't hesitate. Call the 8. Also, feel free to visit us at www.brentadams.com or our Facebook, and our expert team of legal specialists we'll be happy to hear from you. Once again, the number is 910-888-8888. We make things right. Have you been in a crash, injured in a slip and fall, hurt at work, denied Social Security disability? Don't hesitate. Call the 8. All right. So we were talking about UIM, liability, tender of the limits. I hope I made things as clear as possible when it comes to, I always say we're trying to get all the money, right? So, and that would be a tender of the liability, and UIM if there is some. Now, there should always be, again, the new limits of $50,000 minimum liability limits and $50,000 of mandatory UIM that doesn't have a set off. So, but not every case is going to be a $100,000 case. I explain this to people. One of the things that you'll read in Mr. Adams' book is that we don't take every single case. If there's minimal to no damage to the vehicle and minimal to no real personal injury, then you are much better set to try and settle that with the insurance company yourself, right? And you'll read that in the book. We take a third. That's the standard across all personal injury attorneys in the entire country, from what I understand, is 1/3 is attorney fees. And so that's, if your case is very, very small, that fee is going to eat away, and the medical bill is going to eat away at any pain and suffering money that you would be entitled to. So when it's a very small case like that, we usually just direct you and or give you maybe a pamphlet or some information in the book Mr. Adams has that says we would send out to you to help you get the case resolved yourself. And again, if you call us and you talk to us about it, then you'll get an intake specialist, and then you'll talk to attorney Emily Hickman, who is our intake attorney, who will review your case and talk to you about it to see if it's something that we would likely take. And every single one of those cases is reviewed by Mr. Adams himself. So please understand that when you contact us, we take your case seriously. We want to be your friend even if we can't help you. And we're going to investigate and explain to you why we think that, whatever reason that if we don't take your case, whether there's a liability issue or it's just not the type of case that we deal with, or if it's just a very small outcome and you'd be much better served of settling it yourself. And I've done that, where I've worked up whole cases and given it back to them just because I didn't feel right for taking any type of fee because it was so low. So under the circumstances. Now, we hope that that is never the circumstance. We hope that every single case that comes in is going to be the best possible scenario to get you as much pain and suffering and inconvenience money as possible, pay you all of your medical bills, and get you back 100% healthy and whole under the law. So we hope that you call us, 910-888-8888. And I'm going to turn it back over to Bonnie and see if she's got any more questions for me.
Awesome. So you've talked a lot about how our clients can help protect themselves by seeing to their UIM, and MedPay coverage. What about gap insurance?
Oh, that's a great question. So this has been happening a lot more recently, I think, because our interest rates are so high maybe, and the economy has just changed, and car prices went crazy after COVID. I mean, used cars were more expensive than new cars at one point. Like, it was just wild. And then all of that dropped and everything's back, and, some people are in bad deals. So if you bought a car at any time and you did a very bad deal, like, you got 16% interest and you didn't put any money down, and so you owe away, and it's, a bad contract where they're getting their interest up front, so you're not paying anything on the principal. So you are very upside down in your vehicle, right? So you bought a vehicle and you owe way more than the vehicle is worth. Right? And then let's say some defendant, failed to stop at a red light, smashed into the back of you and destroyed your car. Under the law, they're only responsible for the value of that vehicle, not the bad deal that you made. So if you owe more than your car is worth, you have negative equity is what it's called. They're going to pay off the value of the car to the lien place. And what that negative amount, you're still going to owe. You're still going to have to make payments on a car you literally don't have. Or you're going to roll that negative amount into a new car and owe more than the car is worth on your next car. It's very important that, not to give financial advice, but because I'm not your attorney. We're going to disclosure on there. This is just general advice. Make sure that you buy a vehicle, if you can't get it at a good interest rate, you make sure that you put enough down that you're not going to be upside down in the vehicle. You can monitor how much you owe and how much the vehicle is worth to make sure that you're not upside down in a vehicle. Because the defendant does not owe you for making a bad deal. Under the law, they only owe you the value of the car. So I've had quite a few cases, unfortunately, where they, and these are small used vehicles. They just made a bad deal, and after everything was said and done, they still owed $4,000 on their car, and it was terrible, and they didn't have any gap insurance. So if you are in a bad situation and you have to get a car, so you're going to get a bad interest rate, and you don't have any money down, and you're upside down in this vehicle, you make sure that no matter what you do, you get gap insurance. Gap insurance will pay the difference between what the total vehicle is worth and what your loan is. That is what gap insurance is for. So you talk to whoever you buy the car from and tell them you need gap insurance. review the policy and make sure that it is exactly what I just said, that it will reimburse, it will pay off whatever the loan amount is if the car is totaled for some reason. So if you turn around and drive off that lot and some huge truck just comes and T-bones you, that you pay at least back to zero, right? They're going to pay off whatever is owed. Because that is a horrible situation where I've had to just try to make enough money in the personal injury claim for the defendant, for the plaintiff, our client, just to try and get them back to zero. I mean, it's just horrible. Or enough to put, down on a new car and then have the negative equity turned over. It's just a terrible situation to be in. And it's very common in my field because your car is all of a sudden totaled when you weren't expecting it. And now you owe more than what the defendant legally has to pay you. To put you in a position back, and we can sue, but that's not something that has value for the attorney or for you, because we have to take a fee, and they only pay what the value of the car is. What we could get a jury to agree with different types of property damage claims. And so if it's just a certain, there's like no more, there's no pain and suffering, there's no X factor in property damage that could get you cover enough of the attorney fees. It's just enough to pay what was damaged, right? So anytime that you have an attorney, it's going to negatively impact what you would get there for actual direct value. I don't know. I guess that's the best way to explain it.
Yeah, I mean, we don't take any fee off of property damage that we help clients with, because, like you said, all we can get is the amount that the car is worth. So
let me clear that up. So if we do, there are property damage claims that we can take, but with the understanding, and it's very, very rare. I think the only one I've ever had anyone here take to trial was, it was a very fancy special car. I don't know, it was some like Porsche something that the woman had, and they were refusing to give her what we deemed was the value of the car. And it was just for an attorney to cut her teeth on a property damage claim. She was new, and Mr. Adams helped her take that case to trial. Even though we took a fee, the client didn't care that she was not going to get, the full value, because we had to take a fee. We fought the case for her and took it all the way to trial. I mean, trial is expensive. She just wanted her day in court, and it was good experience for the attorney. But unfortunately, the cost of trial and putting on experts and depositions, and it's just so costly. It has to be a decent, large amount of money that we're arguing over, or potentially arguing over, in order for it to justify the cost. I believe that woman in this case, I think, might have paid the fees up front to fight for her car. It was a very rare situation. Now, what Bonnie is talking about, where we don't take a fee, is where we simply assist from the sidelines. You can talk directly with the property damage adjuster, which is a different person than a bodily injury adjuster, and they have to come out to, look at the car, take pictures, either or send it off to wherever it needs to be fixed, and work with those people. That is much faster when the client directly deals with them. We're not coming out to your house to wait for the adjuster to show up, all right? It has to be you. And we deal with clients and work with clients all over the state of North Carolina, so that just wouldn't be feasible for me to drive out to, Chatham County and wait. To work with the property damage adjuster. And usually the property damage adjuster that comes out to the house is not the same one that you deal with on the phone. Those are in-field property damage adjusters who do nothing but drive around and take pictures of cars, no matter where they are, junkyards, at your house, wherever they are.
Interestingly, also, they're not mechanics.
No,
but
not at all. They are insurance adjusters, field adjusters. They are not mechanics. I don't know what training they even have. They take a lot of pictures underneath the vehicle in order to see what type of damage there is, because there's certain things. It's really what is the value of those, right? So if the frame is bent, it's automatically totaled. They look for things like that, whether or not because they're just looking for percentages and values, and they will total a car just because of the year, even if the damage isn't just because of the year. Like my mother has a 2013 for his SHO, and it's, you know, she's spent a ridiculous amount of money on this car, so it's fancy, and she just refuses to get rid of it. She spent so much money. It's got a brand new engine in it. It's all ridiculous, and she had a very minor incident where some things flew off of a vehicle and damaged underneath of the car. She had it fixed herself, sent them the bill, and they were going to total the car. She was like, "Are you insane?" And just because of the age. And I was like, the car's perfect. Why would you try to total the car? It's in immaculate condition. So you really got to fight for these people. You know, like, you fight with them. I always tell my clients that they can work directly with the insurance company, and I'll usually go over whatever the offers is with them. But even if I'm not dealing with that, or you're not my actual client, I always say, don't ever take the first offer. Right? The easiest thing to do when it comes to property damage that you can do yourself is you get all the information for your vehicle, you put it into websites like Kelley Blue Book and Auto Trader and all those, and you get an estimate, right? Carvana, any of those places, you get a value of your car, and you want to get the highest values possible, and you average those three together, and that's what that's what they should be giving you, right? So they're going to, you know, give you a low ball, that lowest one, and you want the highest one, and so you meet in the middle. That's really the best way to do a property damage claim, quickly and get it over with. Yeah.
So you can get the money required to maybe get another vehicle.
And don't just take whatever they just pay to fix the vehicle. You ask them for more money to pay for the diminished value. And just add that on. They'll give it to you. Let me tell them, or I'll get my attorney involved.
Do you think we have time for another question?
Yeah, we got 9 more minutes.
Awesome. So here's one that I kind of know the answer, but I'd like for you to talk about it. How long does it take our clients to get their money?
Okay, so that is a great question, and some clients are not as patient as others. But your claim is directly related to your treatment. Right? We are in the evidence business. Objective evidence is medical records. If you do not treat, your value of your case is so much lower than you would expect. Right? So you can't just go to the emergency room and expect to get $10,000 of inconvenience because the car crash scared you and you were in a car crash. It was just a traumatic event. So the traumatic event, it needs to be an injury. And I always tell people, because it takes usually a few days to really feel the effects. And then sometimes, especially if there was a TBI, it can take up to a year for your brain to heal itself properly and for you to feel back 100%. The most important thing is for you to get your treatment. Check everything. Make sure you get an MRI of anything that hurts, right? To make sure that you know that your knee hurts. Well, is it because it's just sore, or did you tear something inside of your knee? You just never know. And you only get one shot. You know, in personal injury, there's only the settlement. Everything comes out of the settlement. The medical expenses, any liens, attorney's fees, any costs, everything comes out of the settlement, right? So you have to make sure that you know that exactly the extent of your injuries so that you don't settle and say, oh, well, I just want to get it over with. I don't want to deal with it. And then 6 months down the road, your knee is hurting you so bad, you finally go get the MRI and you find out that you have to have surgery. And it was all because of the crash, but it's too late now because you settled and you signed the release, right? So it's not about time. It's about healing. It's about making sure that we know the full extent of your injury as humanly possible, and to make sure that you are as best or better at the condition you were before the incident. So this gets very wishy-washy when we have pre-existing conditions, right? So I have one that I'm fighting with right now where she's only in her late 30s, but she had, in her MRI shows very, degenerative disc disease. Well, degenerative disc disease is like gray hair. Everybody has it. The question is whether it hurts. Does it cause you pain, or was it asymptomatic? And then the crash and the impact is what caused those herniated discs, or the narrowing of the disc, or the abutment onto the nerve root. Finally, that impact and that pressure caused it to start hurting. Now, that's a big difference. And they're fighting with me that it was pre-existing. It wasn't pre-existing. She had never been to a doctor before about any neck pain, didn't know she had any of these problems that they're saying were pre-existing, and now she has pain. And so that was the catalyst to the pain. It caused the pain. So we need to be able to really go into detail and get doctors and different experts to look at that and explain that to an insurance company. Because even though your body was in this condition, if you weren't feeling any pain due to that condition, then it didn't count. It's technically a new injury. And it's not a pre-existing injury that was exacerbated. This was a new injury. And we need to know the extent of that. So sometimes it takes a really long time. And if I have young clients who I have two right now that are so young that the doctors refuse to do surgery because they're so young, so they're not a candidate, and they're just going to be treating for years. And so I'm sending off demands with the understanding that this is a permanent injury, but we have to get the doctors to explain that. Just because you say that this hurts and it was caused by the crash is not good enough. That is what we call subjective evidence. We need a doctor who's going to say, yes, this is an injury and it was caused by the crash, to a medical degree of certainty. And that is where we get proximate and causal injuries. And so that's why you have to treat with these doctors. You have to explain everything to them. You have to get the imaging. You have to do whatever they say that you need to do in order to get them to agree that this injury was caused by the crash. You know, some doctors out there are great plaintiffs advocates and really understand how the car crashes can, or any type of injury can cause certain things. And some of them out there don't want to be bothered at all. Some of them say, oh, well, if I didn't have an MRI the day before the crash and then the day after the crash within hours, then I can't possibly say that. But that's just horrible, right? So it has to be, the only thing we can do is show that there was no medical records prior stating any type of injury, and then after there was. And it becomes a jury issue, you know, and like that's one that I'm probably going to have to file suit because I completely disagree. I gave them 2 weeks to give me the money or we're going to file suit because I completely disagree with them. And I mean, sometimes we have cases like that where it's going to be worth it just to go to trial because we need to prove to get causation. And we'll talk to the doctors in advance, make sure we have causation before we file a suit. So it really just depends. So again, the question was, how long does it take? It's not about how long it takes. It's about how your injury is healing, to make sure we know the extent of your injuries and that we have come to some type of conclusion of where you have reached either medical maximum improvement or you are as in good condition as you were prior. That is how long your case takes. So remember, the goal is to get you as much as possible. So it's not about time. So as negotiations also, I'm very strategic with my negotiations. Sometimes I just give the adjuster crickets for a couple weeks, let them sit and stew, and let them know that you're not desperate to settle right now, and I'm not going to take that. And it really does work. And so you just have to be patient. And that's after we've already started negotiations process. But before that, again, it's not about time, it's about healing. All right, and then we got 2 minutes left, so let me read this off. Making the Law Work for the People is what you're listening to on WIDU 1600, sponsored by Brent Adams and Associates. Don't wait, call the 8-910-888-8888. I tell people all the time, if you've been injured at all, just give us a call, and our wonderful intake staff is here to help you and assist you in every way that we can. Visit us on www.brentadams.com and on Facebook. Our expert intake team and specialists are here to help you. 910-888-8888. We make things right. Our music isn't starting, so I guess I'll keep talking a little bit. We got 1 more minute. All right, if you were in a crash or injured in a slip and fall, hurt at work, or denied Social Security disability, don't hesitate. Call the 8. And as a loyal listener, you can call that number, 910-888-8888, and ask for any of Mr. Adams' books. Amongst them is the 10 Costly Mistakes That Can Wreck Your North Carolina Case. Also, How to Get Top Dollar for Your Workers' Compensation Claim. And Mr. Adams' newest book is The Truth About Medical Malpractice Claims. These books are available for purchase on Amazon.com. But as a loyal listener to WIDU, you can call our office and get a free copy sent to you in the mail. So reach out to us, 910-888-8888. And we'll follow up with a free copy of one of Mr. Adams' books. Don't hesitate. Call the 8. Thank you.
Look at that lady
Yeah. She done got a praise step on already. Before this thing is over.